Yes, so without any further delay, I would like to introduce our guest speaker. So it is actually my great pleasure to introduce our guest speaker today, a prolific researcher and eminent academic from India, Professor Paromita Chattoraj. Paromita is a professor of law from the National Law University of State of Odisha in India. She is a gold medalist from the University of Calcutta and completed her PhD in the area of rape law. Till now, she has worked on several international funded projects and published numerous journal articles and book chapters. One of her achievements included giving a keynote speech on Delhi gang rape, the media's role as the game changer, and the curious case of the BBC documentary India's Daughter at the Loyola Law School, California, a few years back. I was actually fortunate to meet her at the European Criminology Conference earlier this month and getting to know about her work. So today she will be presenting her recent study titled Investigation and Trial of Rape Cases, Results from the Cross-sectional Study Conducted in 3 states of Eastern India. So over to you, Paromita.
Thank you very much, Dr. Mohua Kanjilar. And it's my absolute privilege to be invited to your university, although in the virtual mode, and give this talk. And I also thank Chris because he is very much involved in this whole process. And I know that the topic of rape itself, irrespective of where the research has been conducted, it is so contemporary and it has such an universal appeal that anybody from any part of the world can relate to the risks that are associated, the vulnerabilities that are associated, and the impact that anybody can have if someone unfortunately finds himself or herself placed in such a situation. So I would just start off by sharing my presentation here, and just allow me a couple of minutes. I'm just sharing my presentation. So, yeah, please let me know if you can view it. Are you seeing it? Can you see the slides?
Yes, yeah.
Yeah, okay. So the topic that I will be talking about today is investigation and trial of rape cases. And I will be presenting before you the results from this cross-sectional study that I had conducted in the 3 states of Eastern India. And this research was done with a few of the research scholars who collected the data for me in these 3 states. And one of them is present here in the audience, Ms. Sonali Swet Padma. And she's not only a PhD research scholar, she's also an assistant professor at the School of Law, KIIT deemed to be University. So before going into the depths of the topic, I just want to present to you these pictures. And any of you who were old enough to go through the net or the newspapers way back in 2012 would remember these scenes, because this one rape incident changed the rape law regime immensely in our country. And this is a rape that happened in the capital city of our country in a cold December night of 2012, where in a moving bus, a 23-year-old woman who was returning with her friend after seeing a movie was gang raped. And she was thrown out of that moving bus after being raped by 5 men. And 3 days after the incident, she actually gave in and she did not survive the incident. But what happened with this incident was unprecedented public uproar and dissatisfaction from common people who related with this incident, because this happened in the capital city of the country, and in a time and place where anybody can be placed. So fathers related that their daughters may be placed in such a situation, brothers, friends, boyfriends, husbands, they all understood that this could happen to any of us. That's why we saw a huge number of people. Not only there were demonstrations in the capital city of Delhi, but across the country, and people were angry. They were just disgusted with the current legal system and the governance mechanism, and they wanted some kind of a change which would be a visible change. So what happened after this was some overhauling of rape law. But before I will take you to the rape law incidents. I want you to understand about rape in our country. Because rape in India, you must understand, it is a gendered offense. What we mean is that only a victim who is a woman could be raped by a male perpetrator. So that is the legal recognition in India, which is a complete diversion from what you have in UK. UK, under the Sexual Offences Act 2003, I know that there is a wider offence of sexual assault, where you actually recognize in the UK system of sexual offences against men also. But we do not have that situation, because rape is primarily an offense which is committed against women by male perpetrators. And we saw, if we just go into the statistics, we saw that rape cases has been increasing in number in terms of reporting from 2011 to 12, which seems only 3%. But immediately after this incident, we saw a big jump, where we saw in the number of reported cases about 35% jump. And following year, another 9% jump. So every year, if you see the data here from 2015 to 2021, except for 2020, which was the lockdown year, we see a consistent reporting of rape, which is huge in number, around 30,000 or 31,000 to be, if we take the average. Every year we have these many reported cases, and please bear in mind that this is only the reported cases, because there is huge underreporting of rape cases in India due to lot of social stigma which is attached, because an offense of rape is considered as an offense against the dignity of a woman, and the dignity of a woman is tied down to the dignity of the family. Therefore, there is a lot of pressure from the family not to report such incidents. So in spite of such constraints, we find that the number of reported cases have been consistently increasing over the years since the horrendous rape that we saw in Delhi. Now, in terms of legislative changes that were brought about after the Delhi gang rape case through an amendment in 2013, we see that the definition of rape in our country was changed, because under the rape, an artificial legal construct was introduced, whereby not just penile penetration, but rape by digital penetration and any kind of penetration in any of the orifices in the body by a male perpetrator is considered as a rape under the new law. Apart from that, we find that a lot of procedural safeguards have been introduced in the law itself, and some efficiency dimensions introduced in terms of how to speed up the investigation, how to speed up the trial, and also in case of lackluster attitude of the police, which is one of the very important concerns for us, where we can place accountability for inefficient investigation or for any kind of dereliction of duty by the police. Now, the reason for choosing the 3 states is because we see that in the eastern part of India is a huge country. You see our map, and these 3 colored states, that is the yellow, the orange, and the green, it depicts the 3 states where we have collected the data. And this is because Odisha, that is the yellow one, has the highest incidence of rape, followed by Jharkhand, that is the green one, then West Bengal, which is the orange one. And we find that in the eastern part, there is a huge incidence or prevalence of rape happening in these three countries. So it is apt to study how the new laws that were brought after the 2013 amendment and the Delhi gang rape case, how the laws are faring. So the reason why I can conceptualize this particular research project was because of two laws. One is the Protection of Children from Sexual Offences Act, which is in short also known as the POCSO Act, which was introduced in 2012. And this is the first law in our country which was introduced to deal with child sexual offences specifically. Before this, we did not have any special law to deal with child sexual offences. And the second law was in terms of the Criminal Law Amendment Act in 2013, which was introduced after the Delhi gang rape case. And what happens is, in a country like India, the mere promulgation of the law does not ensure the implementation of law. And there is literature to support it, that we find that the understanding and implementation of legal norms brings out the features of its implementation, such as their prescriptions, their acceptability or unacceptability of behavior, and the responses of the subject or stakeholders. In our case, our stakeholders were the police and the trial judges. So we also try to analyze how far there has been compliance or non-compliance in case of legislations which have been brought in to curb specific mischief. And in India, we find that there is a huge gap between what is, that is the actual letter of the law, and what ought to be. So this was the background with which I conceptualized this particular research. The research model that I have chosen here, this is something which is my own understanding and feeling very disturbed during my doctoral research, which was again on rape, where I was trying to see that yes, there are laws, there are good, well-meaning laws. The legislature has brought in some changes, but what if there is a gap in the implementation? Then these laws will only play as lip service. So I identified certain problems in terms of low reporting of rape cases, pendency in investigation, high pendency in trial, and low conviction rate. So these are some of the concrete problems I identified from statistics. And with these problems in hand, I wanted to proceed with one object in mind: to make an impact analysis of the laws at the ground level implementation. So to do that, I followed this research model. First, I identified the exact legal provisions which are involved in this process. So the new laws which talk about better implementation of certain procedures so that the investigation would be effective, investigation would be speedy. So, certain specific laws which gives procedural cover to the victim so that the victims feel comfortable in the legal system, so that they are encouraged to report, they remain with throughout the process of the investigation and trial, and be active members in bringing out the justice machinery. So this is the first thing. So identification of the exact legal provision which I wanted to see whether they were being implemented or not. Second, I wanted to identify the stakeholders which were laden with the statutory duty to implement such legal provisions. So this was the second thing that I identified. In our case, for rape and child sexual offenses, the two stakeholders that we recognized was the police, who were reporting and investigating the cases, and the trial judges who were involved in the trial process. The third step that I took was to identify the variables, and this identification of the variables is based on the legal provision that I took. So I will explain to you how I did it in the later slide. So the method basically that I used was for sampling. Stratified sampling was used to classify the police districts out of the total districts in the 3 states in accordance to the highest incidence of crime. And in each of the police districts, the police stations were selected by simple random sampling where it was ensured that the researchers cover at least 30% of the police stations in each of the police districts, so that we have a representative response. The questionnaire, the questions were mapped with specific provisions of the POCSO Act, as well as the Indian Penal Code and the Criminal Procedure Code. I have just missed out on mentioning these. So the three laws, in all the three laws, wherever the new changes had been brought in, all those provisions I had picked and I mapped the variables with those provisions. For instance, if I have chosen, suppose, reporting, the law mandates that reporting has to be done by a woman police officer. So as a first responder, only a woman police officer can interact with a rape victim. So this is the mandate of the law. That's the provision. So my variable is requirement of women police officer. So that is how I have mapped my variables with the legal provisions. Then I collected the data through interview schedule, which were conducted during 2018 October to January 22. We just finished before the onset of the lockdown, actually, in our country. The sample size you can see from the table. The FTC means the fast track court, because rape trials are supposed to happen in fast track courts, and special courts, SPCs, special court, which means which are special courts for specially trying child sexual offenses. So you can see from here that in terms of courts, the total courts covered were 130. And in terms of police stations, we covered a total number of 211 police stations. So these were our ultimate samples, 130 courts and 211 police stations in all the three districts. Now, for us, the permission process was one of the most rigorous processes, because we did not find a lot of support from the stakeholders, because in terms of encouragement or motivation for the research, there was none. And we had to do a lot of convincing, lot of persuasion. And what we did was we followed the protocol, because we understood that just going to the police stations and asking questions to the police, we will not get any response, we will not get any data. And as far as judges are concerned, the judges will not entertain any loose scholars just going to their chambers and asking them questions. So we had to do it in a proper manner through proper channels. So what we did was we applied for permissions from all the three districts for police. I have only cited here for police, and for courts also we followed the same procedure. So we applied to the police stations, police headquarters of each of the states. From each of the police headquarters, information was sent to the superintendent of police in each of the districts. Then from each of the superintendent's office in each of the district, they sent out in letters to the individual police stations, marking the day when the research scholars will be visiting their police station, and they will have to give the interview. So this same process we followed for courts, because we applied for permission from the high courts of each of the states. From the high court, the information was sent to the different district courts, and from each of the district court to individual courts, this information was disseminated that a scholar would be visiting. And for this purpose, we had to submit our questionnaire beforehand, so that they could vet the questionnaire. And after only they were satisfied that we are not asking any kind of questions on individual cases or individual victims, because rape is an offense which is under the anonymity clause in our country. So our law forbids any publication of the victim's identity anywhere. So we had a big limitation in that sense. So we would not ask individual cases or individual victims data. Therefore, what we conceptualized was that we want to see how these statutory stakeholders are implementing the law, what is their perception of the law, what challenges they face in implementing the law, if at all, and whether they are ultimately complying or not complying with the legal provisions. So this is how we collected the permission for the data collection, and we could get the data from all those 211 police station and 130 courts. Then the variables, the specific variables for this presentation, which I have chosen to show the results, is reporting by the police, the medical examination of victims, recording of statement of child victims. Child victims are child sexual victims. Handling of forensic evidence by the police, charge sheeting by police. Here I want to just explain that charge sheeting, we use this term for disposal of investigation. So when the police investigation is completed, they file a charge sheet in the sense of a police report or an investigation report. So charge sheeting is a step which symbolizes completion of investigation by the police. So that is also what I will showcase here. And I have chosen certain trial variables like trial presided by female judge, average length of trial, trial on a day-to-day basis, which is a mandate for rape cases. That's why rape trials happen in fast-track courts. Otherwise, ordinary courts take longer time to go on with the trials. Then next is use of audio-videographed statement of victim and use of forensic evidence. Lastly, victim-friendly environment in the court for child victims. So these are the variables that I will be showcasing today. The descriptive results of some of the selected police and court variables. So you can see here from this graph that presence of women police officers, we asked them the question whether women police officers are there in the police stations or not, because the law requires women police officers to play a very important role in case of rape and child sexual offense cases. Therefore, we need to ensure whether women police officers are actually working in the police station or not. And to our surprise, we found that there are some police stations where in Odisha, about 24.6 police stations, they admitted that there were no women police officers. In Jharkhand, there were 16 police stations where there were 16% police stations where there were no women police officers. In West Bengal, it is 31. So, and the orange strips represent that there are only less than 5 women police officers. So we were curious and we found out that the registration by women police officer, registration means once an information of an offense is given, the information has to be registered by a police officer. In case of rape, the mandate is to be registered by a woman police officer because it is presumed that male police officers are hostile and victims are not comfortable to open up before male police officers. Therefore, women will be more sensitive in handling the victim, and ultimately that would showcase a more comfortable and convenient way of reporting for future cases also, and it serves as an example. So therefore, we asked this question to the police officer that whether the women police officers are registering the information or not. There we found that in 94% of the cases in Jharkhand, it is not being so. In 82% cases in Odisha, it is not being so. And in 44% cases in West Bengal. So in spite of a mandatory legal provision, there is non-compliance. When we ask them the reason for this, we ask them the reason for not complying with the registration by women police officer. There, the reasons we only indicated them that whether there is lack of women police force or that they believe that any police officer can do it or any other reason for non-compliance, or always it is registered by women police officer. With respect to the yellow strip, we find that only in Jharkhand in 4 and West Bengal in 52% of the cases, always registration by a woman police officer happens. Otherwise, lack of women police officer is a big reason in Odisha, in 24% cases in Jharkhand, and 37% cases in West Bengal. So this is the reality. The compliance of law is a big question mark when it comes to registration of sexual offense cases by women police officers, although the law has mandated it. Next, I want to highlight this particular variable, that is recording of statement in child sexual abuse cases, because the law has specifically given certain expressed provision in terms of mandates which should be followed in case of recording of statement by the police in child sexual abuse cases under the POCSO Act, our special law. So it mandates first and foremost that such a recording should be done by women police officer. And in fact, it says that the recording should not be done at the police station, and it should be either done at the residence of the child or at a place of convenience. And the police must ensure the presence of parents while the questioning or interrogation happens, not interrogation, questioning happens. And there should never be the presence of an abuser. So if suppose the alleged offense is against one of the family members, it is the duty of the police officers to ensure that such a family member should not be in the vicinity when the child is being asked questions. The last mandate is not wearing the police uniform while recording the statement, because a policeman in India with the uniform intimidates. In India, we actually, when children are very small, they are at a tender young age, we use police figures just to feed them, that please finish your food, otherwise the police will come. So this is the common perception, because police are perceived not as friends of people, but rather a kind of a fearful figure. So any police officer wearing the uniform tends to intimidate such a child. Therefore, we have asked these questions, and if you can see that the data, in 59% of the cases in Odisha, the child is being questioned at the police station, 85% in West Bengal, and 16% in Jharkhand, which is not supposed to happen. So although there are other data, but these are the most striking data. That's why I highlighted it. The next mandate is with respect to medical examination of the victim, and the law says that the medical examination, because the most valuable evidence could be retrieved from such a medical examination, it should happen as soon as possible. So we asked the question whether medical examination is being conducted within 24 hours or beyond 24 hours, and we find that to our great relief, that this is one provision which is being followed, and there is a sense of urgency in conducting the medical examination. Now, the next question that we asked to the policemen were with respect to handling of forensic samples. Now, you must understand, in a country like India, although there is no dearth of resources or scientific talents, but we do not have any regulation or law which has standardized the procedure for collecting forensic samples and handling forensic samples. So what happens is that most of the time the forensic samples are diluted, or they are manipulated, and that is why the courts place very less reliance on the forensic evidence. That is why we ask these questions to the police, first and foremost regarding collection of forensic evidence from the body of the victim, and we got these responses. Then collection of evidence from the body of the accused, because medical examination of the victim as well as medical examination of the rape accused, both are mandated by the law as an urgent process. Then the modus operandi of sending the samples for forensic analysis. Next question was time within which the samples are sent for forensic analysis. And lastly, storage of samples until dispatch for a forensic analysis. I will highlight here only last two variables where we found that, to our surprise, that forensic samples are sometimes sent in 41% cases, as I have depicted in the red color, 41% cases and 17% cases in two states beyond 24 hours. So you can imagine that samples of semen or say blood, what will be their fate if they are shipped or couriered after 24 hours. Then we were curious that till this dispatch, where are they kept? Where are these samples being kept? And we found that the samples are mostly being stored at the malkhana of the police station, and malkhana translates to storage house in the police station. And if any of you would have the experience to visit the police station, you will find that malkhana is the last place where we should store forensic sample, because it has no hygiene, no refrigeration facility. So any live sample, forensic sample, if it has been stored at the malkhana, that means the sample is spoiled. And this is the figure that we get, that 46%, 92%, and 43% of the cases, the forensic samples are being stored at the malkhana. Next is the charge sheeting by the police, that is completion of the investigation. Now, the law has mandated that earlier there were no time period fixed for completing the investigation. But after the 2013 amendment, the law mandated that the investigation of rape must be completed within 2 months. So we asked them the question. So, to our surprise, we found that almost 50%, more than 50% of cases in one of the states, Odisha, and West Bengal, almost 90% cases, and Jharkhand, just less than 50% of cases, the investigation is being completed within 2 months. So it is good news. And if there has been a delay, we ask them what could be the reason for such delay. And this is the response we found, that in 6% of the cases, the accused is absconding in one state, and 43% cases in West Bengal, the accused is absconding. So this is again another variable where we find certain compliance from the police. Now we go to the court variables, some of the court variables. And here we find that there is again a mandate, although it is not a mandatory provision of law, but it has been provided in the law that female judges are desired. It is desirable desirable for the female judges to preside over trials of rape as well as child sexual abuse cases. Again, because female judges represent a more sensitive face, sensitive account, sensitive environment where the victim can feel comfortable rather than a male judge. So we found that in rape trials, when we asked the question to the judges whether the female judges are actually presiding over rape trials or not, we found that in this particular situation, West Bengal, the orange strip which represents one of the states, it says none in almost less than 45% cases. So we find that this particular mandate does not find much compliance. The next question that we put was to judges who are present for trying the child sexual abuse cases. And there also we find in West Bengal, the female judges are not actually presiding over child sexual abuse cases. Although in Odisha, we find little bit compliance, but very little. Jharkhand also just above 5% compliance. But this particular desired provision has not found much compliance. And the main reason for that is the unavailability of female judges in the judiciary in our country. Now, some of the other variables of rape trials that I want to highlight here. The average length of trial, we found that more than 1 year is 1 year in about 44% cases, and about 32% cases within 1 year is completed. So we find that 44% cases takes more than a year, though rape trials are fast-tracked and the law mandates that rape trials should be completed as soon as possible. There was no time period mentioned before, but now it mentions that rape trials should also be completed within a period of 2 months. So that again has some kind of accountability for the judges to take up the cases on a day-to-day basis. That is why we ask the next question, whether the cases are tried day-to-day basis. When I ask day-to-day basis, that means there are no adjournments, and every day the case progresses. So we found that in 60% of the cases, the trials happen on a day-to-day basis. Where they are not happening, the reasons that have been given, in 17% of cases, there is large pendency of cases. That is why there is delay. Also, in certain cases, that is 13% of the cases, witnesses are not turning up. That is why the trial is not being conducted on a day-to-day basis. The next variable is high pendency of such cases. And we found that the reason for such high pendency is frequent adjournments in 60% of cases, delay in production of the credible or material evidence in 88% of cases. This material evidence can be the medical evidence, can be any other evidence, maybe a neighbor or any who will give a oral deposition. So delay in production of key evidence is one of the major reasons for the pendency of trial cases. Next is delay due to load of already pending cases, again pending cases, and already delay in receipt of forensic report in 56% of the cases. The next variable that we used was use of audio videographed statements of rape victims. Now, the law permits that while recording the statement of the victim, it can be audio and videographed. The intention of the lawmakers behind such provision is clear, that they want to relieve such a victim from going to the court again and deposing and repeating its horrific account over and over again. But we find that in 62% of the cases, although the statements of the victim are audio videographed, it is not being used by the judges during trial for corroboration. Rather, the victims are again being called to the court and they are being questioned. 18% of the cases, neither the prosecution produces such recorded statements nor the judges ask for it. So there is a complete apathetic tendency in 18% of cases from both fronts, from the prosecution side as well as from the judges side. Lastly, we asked the question on reliance on forensic evidence, because forensic evidence can be a key game changer. But we found that in 68% of the cases, the judges responded that they always allow forensic reports as evidence. But there is a important rider here, that in 76% of the cases, the judges said that they considered the forensic evidence credible only when it is corroborated by other evidence. So standalone, the forensic evidence as a standalone evidence is not considered as a substantive piece of evidence for pronouncing the judgment. It has to be corroborated by some other evidence, maybe an oral evidence. Only then the judges will believe in such evidence. Similar questions were also put to judges trying the POCSO cases, that is the child sexual abuse. And we find that in average length of trials, within 1 year, only 43% of the cases, the trial is being completed. The reason for the high pendency, we find that delay in production of credible evidence is 74%, delay due to load of already pending cases, 58%, delay in non-procurement of witnesses is 74%, and delay in receipt of forensic evidence is 41%. For use of audio videographed statements of child victim, which is more important in case of child victim, because the child must be absolved from repeating his story over and over again. But we find here again, 62% of the judges do not use them for corroboration during the trial. Second, we find that 12% of the cases, the prosecutors have never produced it and the judges do not ask for it. Lastly, in case of child sexual offenses also, the reliance on forensic evidence is found only in 44% of cases, but in 69% cases, the judges take into account such forensic evidence only when they are corroborated by other evidence. So the last variable that I want to just showcase is some of the mandates in terms of victim-friendly environment, which the law has brought in, both in the POCSO Act as well as the Indian Penal Code and the Criminal Procedure Code after the Delhi gang rape case. And these are some of the variables. If you can see it here, that we find that child-friendly atmosphere in POCSO courts, the steps that that can be taken. One of the steps is a general feeling of making the child comfortable during trial. For that purpose, there are certain legal mandates like in-camera trial. In-camera trial means a trial which is not a public trial. Usually all trials are public in nature, where any member of the public can witness such a trial. But rape and child sexual abuse trials are restricted because only the parties involved can remain in the law in the courtroom when the trial is being conducted. This is again to ensure that the child does not feel intimidated by the presence of other members of public who are strangers. Next is number of times the child is called to the court to testify. And we find here that there are accounts where once we ask them where are they being called once, or they are being called number of times, as many times the court requires. So or it is case to case basis, and we find that in 27% of the cases, the West Bengal, it says that they are called only once. But in Odisha, only 5% cases, and in Jharkhand, only 7% cases, they call the child once. Otherwise, child is called many times. Next, the questions put to the child by the advocate. In terms of that, there are certain important mandates that the question should be such which should not intimidate the child. Secondly, that the question should be put in a manner which could be understood and responded by the child. Third is that the judges should allow the questions submitted to him first, and then the judge should put the question. Next is the advocates, whether the advocates actually submit the question to the judges or not, or they are asking the question directly. We asked that to the judges. We wanted their response. And the next one is the presence of the parents, which is again to build up the confidence of the child, and allowing frequent breaks when the child is making the deposition. And if you see on the right hand side, all the red marks are the alarming figures. So we find that while the judges allows questions submitted to him, it is only 5% in one state, 33% in West Bengal, and 10% in the third state. That means otherwise in rest of the cases, it is the advocate who are directly addressing the child. In terms of allowing breaks while the child is being questioned, we find this particular figure on the right hand side, where only in 4% cases in Odisha the response is yes, 27% cases the response is yes, and 8% cases the response is yes. 11% of the cases in West Bengal, they say sometimes. That means this very basic requirement of providing breaks while the child is being questioned is also not being complied as a foolproof procedure. So this is what the state of affairs is, and I hope that it gives you some indication of the compliance of the law in terms of rape cases in our country. And I think now I can stop the sharing. Yeah. So I'm happy to receive any questions if anyone may have. And I'm sorry if I have really taken your patience for granted because I
No,
wanted
thanks
to
so much,
present.
Paromita. I mean, I couldn't stop you because this is such a grouping research. So, I mean, thanks for sharing with us. I'm sure there will be some questions. And yeah, anyone wants to ask any question to Paromita? I can't see. Chris, can you see any questions on chat? I can't see any hands, and somehow it's...
There's nothing in the chat just yet.
Okay. Oh, Elaine raised her hand. Elaine?
Yes.
Sorry there, I was trying to remember how to work Zoom rather than Teams. Hello, Paromita, lovely to see you again. And
Thanks, Ellen.
thank you so much for agreeing with Mahua to do this. It's really exciting. One of the things I think I know some of my own work has focused on, and I don't expect you to be able to answer this straight away, but I think it may be something you may also think is interesting to reflect on, is the when we have as countries these fantastic legal frameworks. I know, for example, because of work I've done around youth justice, that India also has the most amazing legal framework around young people and going into custody. But we ourselves have some fantastic frameworks around sexual violence and around violence against women and girls generally. And we know, for example, that less than 5% of rapes in the UK end in prosecution, and even less end in actual finding. So what I wonder is, what do you think it's possible to do to actually tackle, and because I think your research does speak to that, tackle these justice systems that look fantastic on paper and allow countries to go to the UN and other bodies and say, we have these brilliant frameworks, but which in practice literally do not work for women and girls and children who are subject to violence?
Yeah, that's $1 million question, actually. So, and my students keep asking me that in spite of such stringent punishment, we have now for certain rapes with minors, punishment minimum term is 20 years. And the maximum term is life term, and which can also extend to death penalty. In spite of such stringency in the punishment, if that doesn't act as a deterrent, if that is not strong enough message for people to really abide by these laws, then I don't know what would work. But yes, the way the law is perceived, it really depends on how the stakeholders behave, their approach to the victim, their approach in general to the compliances. That really creates a sense of urgency. And I believe that if there is that kind of a sense of urgency from the stakeholder side, if a victim knows that if I go to a police station, there will be a patient hearing, the police officer will not judge me, the police officer will not try to find faults with me, that whether I have precipitated my offense or the rape or not. If the victim is sure to receive some kind of a comforting treatment from the police, when the case goes for trial, it happens, if the trial happens on clock precision, on a day-to-day basis, and the result, the judgment is given within a fixed time frame, and this should happen for at least some period in order to gain the confidence of the people, and also to deter people that yes, the legal system is razor sharp now. So anybody who violates this law is sure to be booked by the law, and the justice delivery mechanism is not lax. It is very sharp, and it will definitely work, and it will pronounce justice for the victim. So this is a message which has to go. The message is twofold. Message for prospective victims that they will be handled with care and comfort, and to prospective criminals that if they really end up doing such act, the consequences are going to be very severe. There, every stakeholder, every member of the criminal justice system have to work in tandem, and there has to be a sense of accountability and a mechanism of check and balance for delays, for non-compliances at every step. If we can create that kind of urgency and a seriousness of purpose, as a criminal law researcher, I hope that it might show some impact. That is what I can say from my side with little bit of my experience of dealing with this particular offense and the laws relating to it over the last 1 decade.
Thank you. I think that's really interesting. I think that fits very nicely with a paper we're writing at the moment around safety as well in women, and about whether women are responsibilised or whether in fact systems take action. So thank you.
Yeah.
Any other questions for Paromita? If not, then can I ask one question?
Please,
That's
please.
methods, not purely methods, it's challenges of collection of data, because you actually touched on it. How challenging was data collection process? Because you said there's 3 different states and you actually reached and you explained how difficult it was to be agreed on the data collection with the police station, but how challenging was in the field?
Yeah, so the biggest challenge for us was that we were not allowed to take any court records or police records because of the anonymity clause that is placed for rape and sexual offenses. So we had to only understand the implementation of the law from the perception of the law by the stakeholders and their actual practices on the basis of their own admission. See, it's not that we want to take the words at face value from the police officers or even judges, but we had no other ways. So what we did was, from their mannerisms, the way they answered, we made field notes. It's not that we have only considered their verbal communication responses, but the undertones, we have also tried to figure out if they are making contradictory admissions. For instance, I'll give you one example. When the police officers in the 3 states were asked about the presence of women police officers in the police stations, they admitted that there were none in some of the police stations, which cannot be a case because we dig up police data from the official records and we found out that if we see the proportion of lady police officers in terms of the number of rape cases in that particular state over a period of 1 year, the case load is not that high and the number of police station is quite high. In terms of, if I remember the figures correctly, for Odisha it is 1:9. In Jharkhand, I'll not name the case because I may be incorrect, but I remember the figures. It is 6, 9, and 11:1. So that means for every police station, minimum 1 female police officer is bound to be there. In spite of that, if it is not there, that means there is some problem in the allocation of the lady police officers, or the lady police officers are not doing their jobs in the police station, but they are engaged elsewhere. So these kind of practices we had to understand. First, from the response, we take the response on face value, and then we try to corroborate it with other official data. So this is one challenge in terms of methods I'm saying. But the next big challenge that we had was in terms of willingness to participate. So although when individual police officers or individual judges were contacted by my research scholars, most of them have been very good with my research scholars. They understood the urgency of these young research scholars. That too, all the 3 research scholars were female research scholars for me who were working. And they really appreciated that they are traveling far and wide and trying to collect data. And they are doing PhD in such a contentious issue. So they were treated with respect and sometimes admiration also. But there are also instances of a lot of indifference. But what I faced was at the time of seeking permission from the top level. There I found, especially in the state of West Bengal, so much of procedural red tapeism. They were not ready to give us the permission. And in fact, we had to give an affirmation which was certified by a judge that we will not be using the data beyond any academic or research purposes. Only after that, a struggle of 9 months of constant follow-up, the permission was granted in that state. So I understood that nobody wants to actually facilitate this kind of a research. So I was fortunate enough in terms of getting some funding from the government to conduct this research, because, and that too I have to admit, that happened only because of this Delhi gang rape case, because of the debate and the deliberation surrounding this case, which made it a very sensitive issue. So when I applied for funding, the government could not deny. But at the project defense also, I was asked this question that why I want to do a research on rape, because I'm not going to get any data. Nobody will tell about their cases. The court judges will not open their mouths. These are the responses I got. So this is the challenge I have faced on the face of upfront opposition and indifference. We have still managed to collect some data which we are trying to make sense out of.
Thanks so much, Paromita. I'm really sorry our time is over. And I know that the topic is so intriguing and we can have another an hour of discussion. Still, we will have some questions to raise. But thanks so much on behalf of all of us for coming and sharing your research. We really, really appreciate. And thanks everyone for attending this seminar. And I'm sure you enjoyed this talk by Professor Paromita Chattoraj, and hopefully we will see you again next month's seminar. Thanks.
Thank you, Mohani. Thank you, everyone. Namaste.
Thanks, Paromita. Thanks, Mahia.